Following criminal summons issued against the former Executive Director, Uganda National Bureau of Standards, Dr. David Livingstone Ebiru filed a human rights application in the Anti-Corruption High Court before Judge Gen.Muhoozi Kainerugaba, challenging the trial and the summons. Ebiru cited violation of his rights by the IJG's office when they sanctioned the charges against him without conducting prior investigations. Judge Gen.Muhoozi Kainerugaba dismissed Ebiru's application on grounds that it was wrongly filed before her.
The Anti-Corruption Court was established by the High Court Anti-Corruption Division Practice Direction Legal Notice number 9 of 2009, and by virtue of paragraphs 4 and 8.1 thereof, was imbued with the jurisdiction to adjudicate corruption and corruption-related cases. Specifically, this jurisdiction includes criminal offences under the Anti-Corruption Act, the Leadership Code Act, the Penal Code Act, and any other laws that may be related to corruption.
Ebiru now stands summons to appear before the Anti-Corruption Magistrates Court to face the pending charges against him.
A position emphasized by paragraph 11 of Legal Notice 9 of 2009, which provides that the division shall apply the rules of procedure applicable to criminal trials in the resolution of the cases before it. The applicant must follow the procedure stipulated in Section 7 and 8 of the same Act. In this case, Section 7 requires that the matter be referred by the magistrate. I do not find the applicant's failure to follow the set procedure as a mere technicality that can be cured by Article 126(2).
Meanwhile, the Director of Public Prosecutions has withdrawn all charges which were leveled against Gen.Muhoozi Kainerugaba by Hassani Malemabiri's at Buganda Road Court.
When the DPP took over the matter, she referred the matter to the police, having discovered that the only documents that she had were the complaint and the criminal summons. So that is what she referred to the police for purposes of investigation. And over time to, let's say, nearly almost a year, no evidence came through, so the DPP was driven to withdraw the case.
In Buganda Road Court, Gen.Muhoozi Kainerugaba was facing charges of disobeying statutory duties and becoming a common nuisance when he allegedly participated in politics while still serving as a UPDF officer. Hassani Malemabiriz, who filed this case, has expressed dissatisfaction towards the DPP's office for always failing prosecution in his cases.
Because the Constitution Article 120 tells them you take over and continue. Now, even the form they brought, the Constitution says they need the consent of court. Now, it has been handled with Chief Magistrate Kaizi, of course with his incompetence, as I'm going to report him to the Service Commission, that when the Constitution says with consent, you need to hear from the person who brought the case, because this is not a case opened by DPP. But
Malemabiriz has vowed to appeal the decision. Because
we cannot let them take the law in their hand. So anyway, there was no surprise on my part, because this is what I thought in applying for stall proceedings and withdraw, I knew this is what they are cooking. But at the end of the day, we told them stay, they refused to stay. So the matter is going to High Court and the appeal is there, it won't be affected. Anytime the case will be restated, because however long it takes, justice will be served.
Deborah Namamonde, UBC News.